Start. He defendant contested the suit by filing a written statement which he contended that the suit property belonged to his Hindu undivided family and the members of the family were in joint statement in possession of the suit property. Stop. The defendant denied the possession of the suit property over to the plaintiffs. Stop. Replication bracket start further pleading bracket close was filed by the plaintiffs dealing with the averments made in the written statement. Stop. The trial court declined to grant relief of specific performance and passed a decree of damages in the sum of rupees 40,000 payable to plaintiff number 1. Stop. The suit as regards plaintiff numbers 2 to 4 was dismissed. Stop. The trial court framed 11 issues. Stop. The trial court held that though there was a clause to the contrary in the suit agreement, it would not bar the plaintiff's remedy to seek a specific performance. Stop. The trial court held that the suit property was the property of HUF bracket start for short HUF property bracket close of the defendant's family. Stop. The trial court held that the theory of the plaintiffs that there was a phrase agreement under which the price was reduced to rupees 2,90,000 was not established. Stop. The trial court also held that the possession of the suit property was not handed over to plaintiff number 1. Stop. The trial court further held that plaintiffs numbers 2 to 4 were not parties to the suit agreement and hence, they are not entitled to maintain a suit for specific performance. Stop. On the issue of readiness and willingness, the trial court held that as the plaintiffs had kept the demand draft in the sum of rupees 2,60,000 ready, it cannot be held that they were not ready and willing to perform their part of the agreement. Stop para. The appeal filed by the appellants before the district court was dismissed. Stop. The district court held that though, even according to the case of plaintiff number 1, the suit property was HUF property, there was no pleading that there was a legal necessity for the sale of the HUF property. Stop. Moreover, the co-sharers of the defendant were not made parties, and the plaintiffs had not given up their claim against the co-sharers of the defendant. Stop. While dismissing the appeal, the district court held that the trial court's finding on the issue of readiness and willingness was correct. Stop. The High Court, in the second appeal, held that the suit property was the HUF property. Stop. Relying upon the decision of this court. Stop.